Hi there, I'm James Zappagy, and this is Coffee and a Case Note. Uniform Civil Procedure Rule 5.3. This is a rule that allows a potential plaintiff to make an application if that plaintiff is unable to obtain the information it needs to decide whether or not to commence legal proceedings. Okay, that was delicious. Sorry, it's distracting. Today, we're dealing with the sale of a business that, as you can imagine, because we're discussing it in this context, didn't go quite so well as we might have hoped. We have our plaintiff, and our plaintiff is the purchaser. The vendor of the business, the seller of the business, is the first defendant, and there are two other defendants as well. And as part of the sale of the business, the purchaser was provided all of this information, such as profit and loss statements, payroll records, and other sort of financial data. And each of the first defendant, being the vendor, and the two other defendants, gave warranties, promises more or less, to say, look, this information is accurate and the business that we are selling to you is currently in compliance with all relevant laws. You know where we're going. Our purchaser begins to get to work in the business. It's a business that involves a restaurant and a grocery shop, so that starts to tick over. But what the plaintiff finds as it is operating the new business is that the numbers aren't quite where it hoped and expected they would be. And this leads the plaintiff to a suspicion, and it's no higher than a suspicion, that the revenue it had been told about might have been overstated in the initial sale of the business in those documents that came with them, and the costs, particularly employee costs, labour costs, might have been understated. Now, what the plaintiff says is, in essence, I don't have enough information to form a view as to whether there is a claim here or not. And so what I need to do is turn to UCPR 5.3 in circumstances where I'm unable to obtain this information and make an application. And I need to apply to have our first defendant, that's the entity that sold the business, and our second and third defendants, they're those people who gave those promises, warranties as they were technically. And I need to make an application to turn my attention to them for them to deliver up 4 categories of documents. What I want is, the first category is a really broad one relating to financial documents, so a huge number of different financial documents. The second one is financial records in respect of a market stall and a food truck that was operated by related entities to the vendor. So the purchaser has in mind, there might be some of these figures that I'm not 100% confident on. They might arise from the market stall or this food truck. The third category relates to point of sale data, point of sale details, and other bank statements, so just really raw financial data. And the fourth type of document sought are employment records. Now, the parties then get into I'll say argument, because that's technically what it was, but a discussion in essence before the court of which categories are appropriate. Essentially, category A and category C are agreed. Our plaintiff presses category B. It says, I want these market stall records, I want these food truck records. And what the court says is, well, firstly, because the food truck and market stall are operated by other entities, literally other parties who are not parties to the sale of business transaction, it's unclear why those financial records would assist the plaintiff when the plaintiff's already going to have access to these other financial records. So no, plaintiff goes down on that market stall food truck point. Then there's discussion about the employment records. And what the plaintiff says is, look, I did my sums based on the documents you gave me about the hours worked and the employees and the rates of pay, and that all seemed to line up okay at the time. But now that the business is running, things don't seem to make sense in the way I was expecting them to. And so based on that, the court did order the delivery up of those employment records. So our broad financial statements with a couple of tweaks, yes, delivered up to the plaintiff. No to our market stall and food truck records. Yes to our bank statements and point of sale data. Yes to our employment records. And those are yeses were yes enough for the court to make an order pursuant to a different rule of the UCPR, 42.1, which is that costs follow the event. So that means our plaintiff not only got the documents it was after, it also got its legal costs of that dispute. So I hope that little tour through UCPR Rule 5.3 and a bit of a disappointing sale of business from a few perspectives there assisted you, gave you a couple of insights, maybe diverted you, and I otherwise look forward to catching up again very soon for a coffee and a case note. Cheers.